Lordship, I beg to make a mention for item 10, Your Lordship.
Item 10.
Yes, Lordship.
Why?
Lordship, today is having some difficulties, Lordship. So come next week, Lordship.
Hmm?
Item 10.
This cannot be. This,
Next week, Lordship.
matter has been pending for so long. We'll take it up on Monday.
Monday.
On pre-made by the parties or by the petitioner. This is matter on Monday.
Lordship, civil prayer for item 14, Your Lordship. Yes, Lordship. Confirmed.
I'll inform Mr. K.P. Bhattacharjee, my lord, with the government counsel in this matter.
On pre-made by the petitioner, this is matter after 2 weeks.
Highly obliged, Lordship.
Your Lordship, item number 9.
Yes.
Yesterday I was not feeling well, Your Lordship, so I was not informed. I already informed Pro Ronbich of you, so
You are the petitioner.
I have already informed this other party yesterday itself. So I was not feeling well, and I was not in a position to take pain of study. And doctor tell me to take some rest, but still not 2 weeks.
Now the counsel for the petitioner, Mr. R. Tepnath, has submitted that may be allowed some accommodation in this matter since he is not feeling well and could not, since he is not feeling well. On pre-made, the same is allowed. This is matter after 1 week. Huh? 2 weeks. 2015 matter, Mr. And I think we have heard this matter substantially.
Just to explain, sir, I was not feeling well, so doctor also told me to not to take pain of carrying it.
2 weeks.
Number 12, my lord. I'm to the petitioner in this case.
Well,
12. After 2 weeks.
2 weeks.
No objection, madam.
On pre-made by the petitioner. This is matter after 2 weeks.
Okay.
May it please, Lordship. Lordship, I beg to mention for an unlisted bail application, Lordship. For today, Lordship.
Bail.
Yes, Lordship. The difficulty, my lord, the accused person, my lord, he's in hospital, and twice he has been admitted in the hospital, Lordship. Presently also he's in hospital, Lordship.
Oh, even he may be in hospital.
Lordship.
So he has been, you see, he has been given due treatment.
Lordship, but yesterday also we had gone to Nongpo court for moving the bail. For some difficulties, my lord, the bail was not taken up. If my lord may kindly consider. Yesterday we had gone to move.
You have gone to Nongpo.
Yes, Lordship. It was not taken up, Lordship. For that reason, my lord, we are
It was not taken up.
not taken up, Lordship.
Not taken up means as was it rejected? This,
No, not taken up. Because of, my lord, the pre-occupation of the court, my lord, it was not taken up. It was informed that it will be taken up on Tuesday, Lordship.
Once you have moved the matter,
No, we have not
before-
moved.
Once you have moved matter before forum, you should complete it. Why should you
No,
come?
my lord, it was already moved long time back. My lord, it has been 5 months, my lord. The accused person has been in custody, my lord. And presently, my lord, because of his medical
You
issue.
are telling me that you have moved for bail application before the Nongpo court, and the matter has not yet been taken up.
No, my lord. Earlier rounds we had moved, it was rejected, my lord. Thereafter we had come before this honorable court. Thereafter, my lord, it has been almost 2 months. And my lord, yesterday we had gone to move before the learned special judge.
Exactly.
We had gone to file the application, my lord. It is not taken up, lordship.
Yes. So you have to, you see, you have to wait for the process to be complete.
But my lord, it's 439.
Whatever the case may be, you see, Mr. Fateh, you cannot simultaneously oppose two courts.
No, we have not filed it, my lord. We had gone to file it. It was not taken up. For that reason, my lord, we are praying before the Honorable Court, my lord. It was not taken up. We have taken back the application, my lord. It was not registered.
Not registered.
Not registered, my lord.
Let it come on Monday.
Monday, lordship. Please.
Supplementary cost list, item number 1.
Yes.
Main case, Your Lordship.
Yes. Please tell me, Mr. Ahmad.
This bail application was earlier rejected by Your Lordship, my lord. But today, in one case, it is 58 days, and in the other, my lord, 52 days, my lord. Your Lordship had asked the CP, my lord, whether charge sheet has been late, my lord. Otherwise, 60 days is the mandatory period of submitting the charge sheet.
You have not crossed 60 days.
Not yet, madam.
My lord?
Have you crossed 60 days?
No, my lord, today is 58 days.
So it doesn't matter. You see, it's not for you to say. It's for the IO to. It's for the IO to file the charge sheet as and when he feels like it.
Yes, sir.
If the charge sheet is filed beyond the 60 days stipulated period, then you can always come for the default bail.
My lord, I am only praying on the length of detention, my lord, as Your Lordship has earlier rejected, my lord. This both the cases.
No fresh circumstances has been cited, Mr. Ahmed.
No, my lord, only on the length of detention, my lord.
Length of detention.
Well, if Your Lordship pleases, my lord, my only prayer is the Lordship pleases, my lord, ask the, my lord, public prosecutor, my lord, whether they have filed, my lord, tomorrow Your Lordship may fix the case, my lord. Sorry, my lord, on Monday, my lord.
I don't think there will be a valid ground for you to, to argue.
That's right. To be honest, my lord, nothing more, no new ground, my lord, only on the length of detention, my lord.
That will have to wait then. You see, the court can.
Yes,
The court cannot force.
Monday.
The court cannot force the prosecution or the investigation to be completed inside such a time.
Lordship, fix it on Monday, my lord, if possible.
What is there?
My lord, if charge by Monday, my lord, 60 days will be over, my lord.
Even if charge sheet is filed, you still have to come with a plea, or even if charge sheet is filed, then your prayer will be on the ground of on merits.
Yes,
Not on
so, my
anything else.
lord, yes, my lord.
So
So,
this
my lord, I
is-
am praying before your lordship, my lord. The letter may be listed, may be fixed on Monday, my lord. If charge sheet is not filed, my lord, then I'll have the, my lord, bail by default, my lord. And if charge sheet is filed, my lord, then I'll withdraw this case, my lord, and go to the appropriate, my lord, the trial court, my lord.
That is fishing, Mr. Ahmed.
My lord, one small thing, my lord, I want to point it out. If my lord will see the petition, the name of the petitioner is Azizul Islam. He is aged about 28 years. Whereas the accused person, and he is claiming himself to be the uncle and father of the accused number 1, paternal uncle of accused number 2, and maternal uncle of accused number 3. And his age is 28 years, petitioner.
Yes.
Whereas the accused number 1 is 28 years, then 2 is 36 years, and 3 is 38 years. How can he be?
Doesn't matter.
My lord, 28 years, petitioner is 28 years, and he is claiming to be the father of accused number 1.
Mr. Sinkon, I know of a case where the daughter and the mother give birth to on the same day. So what do you see? That doesn't matter. So fine, then you just get instruction.
Take instruction.
Heard
1 and 2, my lord, similar.
Mr. N. Ahmed, then the counsel for the petitioner. Mr. N. Sinkon, then J appears for the state respondent. On pre-made, the prosecution is directed to file the status report as regard the, what is the case number?
This is Sela PS case number 22 bracket 6
Sheila,
2023.
Sheila PS case number 22.
And another one is Sela PS case number 20 bracket 5 2023.
No, this is in the same case.
Second case, my lord.
First
Second
you go,
case, my lord.
Yes, thank you, sir.
by Monday you can do it.
My
List this matter on Monday.
always.
I am obliged, madam. Deeply obliged.
Item number 3.
Who's appearing for the petitioner?
Three and four.
May it please the Lordship.
You're there.
Yes, my Lord.
What took you so long?
I'm sorry, my Lord. I was on the other court. My Lord, this is a matter under section 439 for a bail, my Lord. The petitioner
Just a
here.
minute. May it please your Lordship. Lordship, before my friend start, Lordship, if Lordship, this petition has to be corrected first. Lordship, kindly come to page 7 of the application.
Yes.
Which petition?
This is Anil area, no? Lordship, kindly come to page 7.
Yes.
Accused person Shri Yaman Bansal.
Oh. Well, we'll correct it, my Lord.
Then Lordship, kindly
Where-
come
where?
to page 8.
Page 7?
Page 9, my Lord. It will be page 9.
No, 7.
7.
This is area, Anil area.
This, because, my Lord, these two
No, we are-
petitions are there.
So
The other
they
item
are
number 4,
accused
item number 4, my Lord.
same error.
No, it will not be same error, my Lord. Only the error of the name, my Lord. So, my Lord, let me just complete my submission. I will correct it, my Lord. Because the matter cannot be decided today, my Lord, without calling the CD, my Lord. Here, my Lord, what happened? The petitioner is the father of the accused person, my Lord. The accused, my Lord, was arrested on 26th June 2023, my Lord. The first, my Lord, I will rely on the FIR, which has been filed against the accused, my Lord. That is on page 21, annexure 1, my Lord. My Lord, may kindly come to page 21, my Lord. My Lord, this FIR was filed by ADC comes SDO civil, my Lord. and it was filed before the officer in charge.
This is not FIR.
This is the FIR, my lord.
Just a moment.
This is the FIR, my lord. Page 21, my lord. Yes, my lord. To the officer in charge, Salang Police Station, West Khasi Hills District, subject FIR, sir, with reference to the subject cited above and in compliance to the order issued by the Deputy Commissioner, West Khasi Hills District, Longstreet, white order number so-and-so, dated so-and-so, and closed, to shut down all the illegal coke factories operating in the West Khasi Hills District as per the direction issued by the Honorable High Court of Meghalaya and PIL number 14, dated 16/12/2022, and closed. I, the undersigned, hereby inform that today, the 17/12/2022, accompanied with Ivanmi Lindo, MCS EAC, and with the police force led by Sri D. Malwin, MPS SDPO, Mokrwa, Motion Road, Civil Subdivision, and the officer in charge of Salang, E. Solong, Sub-Inspector, has shut down 57 numbers of illegal coke plant. Their owner were unknown. Further, unclaimed coal and coke along with the diesel generator has been seized the list and closed. Now, this matter, an FIR was lodged by the ADC cum SDO, my lord, before the Salang Police Station, and the case was registered in the year 2022, my lord, and the case number has been given as 39 in bracket 12 or 2022 under section 188/34 IPC and section 21 clause 1 of MMDR Act. The entire sections are available of us at that point of time, my lord. And my lord, on 29/5/2023, my lord, I have a notice was issued under section 41A of CRPC to me, my lord, and the notice is in page 22, my lord, annexure 2. If I am permitted to read, my lord,
Yes.
to Sri so and so, the accused person, my lord, son of Anil Arya, resident of Silver Height, so and so, notice under section 41 A CRPC. In exercise of the power conferred under subsection 1 of section 41A of CRPC, I hereby inform you that during the investigation of Salang Police Station case number under section so and so, read with section so and so, read with section 15 of Environment Protection Act and section 3 of Explosive Act. Here, my lord, now two more sections of two different acts has been put, my lord. One is the Environment Protection Act and the other is the Explosive Substance Act, my lord. Now, in those, my lord, the Environment Protection Act, my lord, the punishment is 5 years, my lord. And in Explosive Substance Acts, my lord, there are twofold, my lord. Section 3 deals with twofold, my lord. One is section 3A and 3B, my lord. I'll just give first the compilation, my lord. These are only the sections. I have just taken the extract of the provision of law, my lord. If my lord may kindly come to page 5. Punishment for causing explosive like to danger property, life or property. Any person who unlawfully and maliciously cause by any explosive substance an explosion of a nature like to endanger life or to cause serious injury to property shall, whether any injury to a person or property has been actually caused or not, be punished with imprisonment for life or with rigorous imprisonment of either description shall be not less than 10 years or liable to be fined, my lord. This is section 3A. And 3B says, my lord, the punishment will be death or rigorous imprisonment for life and shall be liable to be fined also, my lord. So this is the obstacle, my lord, for my lord to consider my bail. Because today, my lord, is the 60th day of my arrest. When I was arrested from 26th of June 2023, my lord. Now, my lord,
Charge sheet hasn't filed?
charge sheet has not been filed, my lord. My lord, may kindly come to the forwarding report, my lord. The forwarding report is on page 23, annexure 3. This is the. I was arrested, my lord. Prior to this reading of this forwarding report, I will just brief this honorable court the facts of the case, my lord. Is this on 29/5/2023, I was summoned to appear on 13. 13 I have appeared. They have issued me another notice under section 41A, and that notice was issued by the DSP. The investigation was taken over by the DSP, my lord, at that point of time. As per that, my lord, on 13 notice, as per the 13 notice, I was supposed to appear on 20th of June, my lord. 28th of June, I have appeared. After cooperating with the investigation, my lord, on 26th, I have received the phone call from the police station of Chala that immediately you come. So, my lord, I have appeared. Being a law-abiding citizen, my lord, I have appeared before the investigation officer at Salang police station, my lord. But unfortunately, even though I was cooperating, my lord, I was arrested on that particular day, my lord. Now, my lord, may kindly see the first forwarding report, that is on 27 June 2023, when I was produced before the Honorable Court. That is on page 23, my lord. And the relevant portion of the forwarding report is on page 24, my lord. Why I was arrested, my lord, even though I was cooperating under section 41, why I was arrested, they have mentioned, my lord. Whereas a notice under section 41A CRPC was issued to Ashish Aryan requiring his attendance on the 20th 6 2023 at 11 a.m. at the office of the Superintendent of Police, Knoxton, for his examination, who has appeared before the SIT on the day and time as specified in this seat notice, and subsequently also on 26 6 2023. So they are admitting, my lord, that I have appeared as required of him. Notwithstanding the above, the said accused person does not fully satisfy the condition required of him under section 41A CRPC that he is made aware of, and that which circumstances are explained as under. So these are the 4 points they have explained why my arrest was required, my lord. Whereas it appears on record that so and so is the co-owner of so and so. I am the co-owner, they have said, my lord, I am the co-owner. And whereas the said accused person deposed in statement under section 161 to be particularly in the activities of at the said coke plant, which illegally is under investigation. His arrest is necessary to prevent him from causing disappearance of evidence, given that evidence and interest person related to the said accused person are numerous and whose integrity has to be protected from the influence of the accused person. This is very pertinent, my lord, why I was arrested. Now, point number D, my lord, whereas it appears that the accused person took stock of the protection given to him through the notice under section 41A CRPC to conceal the fact about the usage of coal at the illegal coke plant. Contrarily, the complainant stated that the coal and the coke was found in an illegal factory, my lord. Now, my lord, may kindly see the seizure list. The seizure list is in page 29, my lord. My lord, we kindly see this was seized by the additional district magistrate, West Khasi Hills, Knoxton. The description of coal seized, my lord. Coal dump seized from 57 illegal coal plant in Shalang area, 9,000 metric ton. Coke seized from 57 illegal coke plant in Chalang area, 800 metric ton. Number of diesel generators seized is 5 numbers, my lord. My contention of reading this seizure list is this, my lord. They have not recovered anything of the explosive substance, my lord. They have not recovered. Now, my lord, to determine whether in the investigation, whether the explosive act was recovered or seized, my lord, CD will be required, my lord. For that, I will just pray at this point, my lord, for the CD to be called, my lord. Before that, my lord, I would like to take my lord to another page, my lord. That is the next page, page 30, my lord, Annexure 4. This is the second forwarding report on 2nd August 2023, my lord. My lord, may kindly skip everything, my lord, and kindly come to the last 2 paragraph that is highlighted with the star, my lord. That in respect of the accused person, Yaman Bansal, Ashish Arya, and Sri so-and-so, sufficient evidence has been collected to establish their prima facie role in the affairs of the illegal plant, Mrs. Yash Coke, beyond any reasonable doubt. So they said, my lord, I am the co-owner of the coke plant. There is no dispute about it. The second point, my lord, is very pertinent. Investigation in respect cannot be expanded any further beyond this point. So, my lord, whatever is required to be investigated, my lord, they have investigated. And in connection with these 3 names, my lord, they cannot expand any more further investigation, my lord. Now, my lord, may kindly see the third point what they have mentioned, my lord. Yes. Charge sheet in this respect will be filed once the investigation is completed as a whole, my lord. That means I am not alone who is involved, my lord. There are other people also. In connection with them, my lord, it appears that the investigation is yet to be completed, my lord. So, my lord, at this stage, my lord, since they have said, my lord, in connection with me, my lord, the investigation cannot be expanded, my lord. And this IO report has been given by the DSP, who is the present IO, my lord. So, at this point, my lord, I am praying that let the CD be called, my lord.
May it pleases your lordship. Your lordship, in fact, the contention raised in various by my friend, your lordship, that has been dealt, your lordship, in one of the.
I have given the judgment also, my lord. It's there in my compilation.
Lordship, in the case of Pawan Bhama, your lordship, that is bail application number 18 of 2023, your lordship. Lordship, kindly see the registration of that case arose out of the order dated 16/12/2022 passed in PIL number 14 of 2022, your lordship. Lordship, only after this order was passed, then the district administration immediately swung into action, your lordship, and found, your lordship, that there were 57 coke plant, illegal coke plant, who did not even have the consent to operate, as well as, or the consent to establish, as well as the consent to operate, your lordship. So that is why, lordship, number of people have been arrested, your lordship, and more are yet to be arrested, your lordship. And the investigation is still going on, your lordship.
Anyway, you produce the copy of the case diary.
Lordship,
Let the court have a look at it.
My lord.
Investigation is completed.
no, it's still going on, your lordship. And number of people also, they are coming for pre-arrest bail, your lordship.
So when?
Lordship, then let come out after 10 days, your lordship. After 10 days.
By 31st, I think you can do it. That'll be next Thursday.
Let it be on 5th, then, your lordship.
Let it be, no problem.
Heard Mr. S.D., Land Counsel for the petitioner. The Land Counsel at the outset has submitted that there are certain typographical error in the petition relating to the name of the accused, and as such error may be allowed to be corrected. As prayed for, prayer is allowed. The Land Council has also made a brief summary of submission on the facts and circumstances of the case. It is, however, submitted that it would be useful for this court to peruse the relevant case diary so as to know the state and status of investigation. Accordingly, Mr. Andishwar AJ has submitted that the copy of the case diary and the latest status report will be filed on the next date fix. As paid for by the parties, this is matter on 5th.
No.
Next item is
Same order will carry.
Same order.
Except, your lordship, that first part, no correction is required.
No correction is required in this matter.
No correction.
Yes.
Katoka first part.
Highly blessed.
Oblige, your lordship.
Item number 5.
Item number 5. Lordship, I'm praying if this matter can be taken at the bottom of the board, Lordship. Learned Senior Mr. K. Paul is on his legs, my lord. He will be appearing.
End of the board.
Item number 6.
This is Lordship. Lordship, this is a contempt application whereby your Lordship had passed an order on 17/2/2023 whereby your Lordship has directed that At paragraph 31 of page 33 of your Lordship's judgment. Page 33, paragraph 31. I'll read from 30.
Yes.
Even without discussing the impact of the authorities cited by the parties in connection with this case, the admission of the respondent, as pointed out above, will only prove that the petitioners has been superseded by 89 juniors and that anomaly created as a result thereto would be rectified in due time. This being the case, this court is of the considered opinion that the respondent authority is to correct and rectify the anomalous situation of the petitioners vis-a-vis their junior colleagues by issuing necessary orders in this respect. The case of the petitioner stands vindicated and the prayer made in this petition is therefore legitimate. The same is hereby allowed. Consequently, the respondents are directed to issue necessary orders as regard the case of the petitioners, as ensure that the standing in the roles as well as the pay structure is commensurate with their seniority. This exercise is supposed to be completed within 6 weeks, Your Lordship. Now it's been more than 6 months, so that's why we're before Your Lordship. So I pray I'll take steps to issue notice to respondents.
Maybe somebody has made some wrong calculation. 6 weeks was taken as 6 months.
Most probably.
We'll have to wait for 6 years then.
I'll take steps. I will suppose.
Heard Mr. P. Nobrera, counsel for the petitioner, as paid for. Let notice be issued upon the respondent
1 and 2.
contender, respondent 1 and 2. The same returnable within 2 weeks. 2 weeks.
2 weeks.
This is the matter thereafter.
All right.
Daily cost list, item number 1.
My Lord, this matter, Lordship accommodate us. I prayed for a week's time. The many councils are appearing. Even the other councils are not yet seen today. So subject to Lordship convenience and convenience of all the learned members here, if Lordship fix a particular date and take up the matter. It's a very quite bulky petition.
What is this matter about?
Land acquisition matter. Border fencing. It's a border fencing.
Why is it come up for admission?
My Lord,
I had raised an objection with regard to the maintainability of the petition.
They can raise any objection. Only my prayer, my Lord, is a bulky petition. I prepare and other learned friend do not prepare. That, my Lord, because of that, to bring convenience to all the parties, subject to Lordship convenience. I propose for that, my Lord.
So you, then you agree on a date?
Well, even next Wednesday or Thursday, subject to Lordship convenience.
Perhaps next week may not be possible, Mr. We have a
first week of next month.
5th or 6th?
Because next week, I think Tuesday, Wednesday, we have DB matter. So the week after that, then.
My Lord. On the 5th or 6th,
my Lord. 5th September, man, that is Wednesday. 5th or 6th. 6th is Wednesday.
Yes.
Lordship fix on
6. On prayer made by the petitioner, not objected to by respondent. This is matter on 6.
Hello.
Item number 2.
My Lord, this matter is fixed for admission. However, may I just point out that the last week, my friend has filed a new petition and Lordship has fixed the matter on Wednesday, coming Wednesday. So only my prayer, my Lord, to the course of action is different. May pray matter may be taken up together on Wednesday.
And there's a writ appeal also pending.
Writ appeal also pending, filed by District Council. So matter may be listed on Wednesday.
Yes, miss.
Then come after 2 weeks, Lordship.
Yes, Your Honor.
You want to say?
Lordship, after 2 weeks, Your Lordship.
He said Wednesday, you said after 2 weeks.
2 weeks, Lordship.
2 weeks, Your Lordship.
After Wednesday, everything will be clarified
Oh,
if
so-
it is disposed of.
Wednesday is the.
Other matter,
The fresh matter which I have filed, Your Lordship,
Which will
regarding
have
the
a
suspension.
bearing on this matter.
My Lord, it has some connection. The course of action is different.
The same post, acting chief, is in question.
With regard to those,
Yes.
That
Downgrade
inquiry
same chief.
report and the.
Yes. That is the matter.
But here the district council is defending the person who has been removed, and in the other case they have removed me.
Or different course of action.
So 2 weeks. On premiered by the parties, this is matter to 2 weeks.
Item number 3.
My lord, and for the respondent number 5, my lord, I want to make a mention that the respondent number 5 expired.
Respondent number 5.
Yes. So let the matter.
When?
Yes, last week back.
Are you going for substitution or?
No, they are still in the bereavement, so they are.
I'll take necessary steps, Your
Take
Lordship.
necessary steps.
Lordship, but there is an pending misapplication, Your Lordship, for pleadment filed by one of the applicants, Your Lordship, in this case. If Your Lordship can hear on that, so if I can.
My lord, since they are in bereavement, let the matter become after a month or something like that.
I'm not pressing for respondent number 5, Your Lordship, in this case.
As far as 5 is concerned, yes, and you will be given some time to decide whether you'll be substituted or not. But implement, do you have any objection for implement? Do you have any objection for the implement?
So far, no. For the implement, no.
Or do you want to consider it just
as it?
But now you will be without instructions.
Yes, we need that also. Yes.
Because they may be affected, they may not be affected.
So respondent number 5 is a different party, Your Lordship.
No, as far as the implement is concerned.
Lordship.
If somebody is coming in as party respondent, or as a party here, respondent or otherwise, it may directly affect the parties present, or it may not. So that is the question, which
in that matter, better 6 instruction from the same.
But then we cannot wait for. Anyway, in any case, it doesn't matter, because until and unless the position is clear as far as respondent 5 is concerned, the matter cannot proceed. Finally, they have to come. So we'll keep it 2 weeks.
Lordship, as far as respondent 5 is concerned, respondent 5 is a different party, Your Lordship. The applicant is a different party, Your Lordship. I don't think so that will have any impact to the respondent number 5.
True, applicant is a different. Yes, I know. Applicant is not at all connected with the respondent 5. But to be implemented where? In these proceedings?
Yes, Your Lordship.
Where the respondent 5 is also a party. So that connection has to be there.
Lordship.
Like I said, may be affected, may not be affected. So we'll take up a matter up to 2 weeks then. Try to get instruction with that. Or 3 weeks, fine. 2 weeks is good enough. Mr. Sakija, the counsel for the respondent 5 has submitted at the bar that the respondent number 5 is since deceased, though the particulars could not be furnished at this juncture, at this stage. Be that as it may, the General Counsel has submitted that he may be allowed to seek instruction in this regard. On preamble, same as the law, list this matter to 3 weeks.
Item number 11.
I think as per the last
So,
order,
where were we?
they had sought for some time to file a reply to my affidavit. Your Lordship will recollect, now, as per the Supreme Court decision, first Your Lordship will have to hear the maintainability of the petition. I don't know, my friends are, I am ready, otherwise.
No, what was the affidavit file?
We have filed an affidavit to bring on records certain information which we have received through RTI. Of course, that would be into the merits of the case. That would touch the merits of the case. But firstly, my lord, as per the direction of the Supreme Court, that maintainability will have to be heard first. Because here they file an application under 227. So do they have an alternative remedy or not?
Yes.
That is the point which has to be decided first. If this court finds that the case is not maintainability, we need not go into the merits also.
What do we do?
It all depends on.
Then we take up the hearing on the issue of maintainability first.
But here what happened, the question of maintainability is so embedded with the facts of the case, my lord. It's not a clear case of barred by any law, my lord. Here, if I argue on maintainability, my lord, I have to refer to the entire sequence.
We have to.
Naturally,
a little bit of the fact has to be.
Actually, how do you you have to at least relate to the court what the background and so on and so forth.
So what do you think for quite some time? So let us fix a date. In case they're not ready, let us fix a.
Yes, so very old matter.
Let's fix a specific date.
First, as far as Mr. Dingdor's submission is concerned, where the affidavit has been filed, bringing on record certain documents of records or facts. Do you wish to file a rejoinder to it, or rejoinder is not necessary? If they are matter of facts, what rejoinder is required?
What they're trying to do is trying to bring on record new documents, new evidence, my lord.
Not new evidence.
After all, this is a civil proceeding, my lord, arising from certain orders passed by the trial court.
It all depends on them whether they wish to file or not, as your lordship has said.
227, you see, 227 will go beyond 115.
Yes,
my lord. Your lordship finds that the trial court has grossly exceeded the jurisdiction, my lord, then only one.
So where's those facts were there, before the trial court?
No, not the trial court, because my lord, in the petition they have tried to make out a case saying that I'm a stranger to the suit. What the petitioner is saying, that I'm a stranger to the suit. But now, your lordship, we will see, as per the information which we have received, this so-called stranger is the person who has been operating the accounts of the State Sports Council together as the director of sports also.
Yes.
In their petition, their documents only would indicate that money has been spent from this account for the director of sports also. That is what I have brought on record.
But the thing is, decree is not against that person, my lord. Decree is against a certain organization, my lord.
Lordship, the latest Supreme Court decision 2022 by President CJI is very clear on execution. I will place that. Plus, your Lordship, 47 is there, Section 47 of the CPC is there. Even a stranger to the suit, if he has any grievances against the order passed by the executing court, they should go before the executing court. This court sitting in 227 is not going to see, but I've just brought on records to indicate that whatever action taken by the petitioner is all illegal. And he has filed a case against himself. As the Secretary of Sports, he has also made the director of the state of the government of Meghalaya Sports Department as a party.
That will,
Of course, that will look.
we'll distinguish as to the office.
What has your Lordship said?
Because the decree is because there are two separate entities, my lord.
No, Your Lordship, they want.
Sports department.
I'll start.
Sports department is one entity, my lord. Just and state sports council is another organization.
Yes, yes, yes.
The decree is against one body, my
That's
lord.
separate.
Maybe the person holding the chair is same person is holding dual charge, my lord. But decree is not against one gentleman, my lord. The decree is against the sport department, my lord. Can state sports council's bank account be frozen for that, my lord? Can it be frozen? But that is the question, my lord.
So we'll look into that.
My lord, if I may submit, my lord, this case has such a checkered history, my lord, that the issue of maintainability cannot be decided in isolation. My lord has to go into the facts of the case, my lord.
No, that will be, as Mr. Ringo has submitted, see, that will look, that will look, see.
Filed our written submissions, my lord.
Written submissions?
It's a long time back, my lord, 2018.
Written submission, my lord. Our plea is that from the very inception, my lord,
Who are you?
has been woven around
They have filed another.
Who are you?
My lord, I am appearing for the state, my lord. So,
state?
The state, my lord, sports department.
And who's the sports council?
He is the Sports States Council, but they are the same people who have sworn the affidavit also. My lord will take that into consideration. Now, the person who has sworn the affidavit in both these revision petitions is the one and the same person.
We'll look into the legal aspect as far as that is concerned.
The factual aspect of this matter itself will take a very long time, my lord.
It won't take. I will take half an hour.
No, we have to take time because we are petitioner.
But I'm challenging the maintainability, so I have to satisfy my lord whether it's maintainable or not.
My lord, what has happened here is an undisputed sum of some 1 crore, 1 crore 20 lakhs has ultimately matured into a degree of 10 crores.
Out of which they have paid 5 crores.
11 crores.
And now they come before your lordship.
Now, my lord, now if I take my lord to the very inception of the case, my lord, this case starts in the year 2001, where there was one given undisputed amount. Thereafter, it multiplied many-fold after 5 years. Now here we are at the stage when it has multiplied tenfold. Now how this has done, my lord, for that we'll have to take my lord into the facts of the case, my lord. And there, my lord, it is our submission, my lord, it is my case that fraud has been played on the court, my lord, and this decree is nothing but it is a product of fraud. And the law is very well is laid down, my lord. Any decree or any order of a court which is a product of fraud is non-existent law, and it can be challenged in any proceeding. Even in a collateral proceeding, my lord, I can take up a decree and challenge it, alleging fraud, my lord. So that is my case.
Fine. So let's do one thing. Let's fix a definite date. And do it.
Yes.
My lord.
We've been going back and forth in this matter.
Yes, yes.
So this will take time.
It may take time, sir. The court has to hear.
Court is there.
The court has always been there, my lord.
We can have it on the 30th, my lord. 30th or 31st.
This 30th.
Not next week.
Not next week. Okay, then my lord, we can go into 5th or 6th.
Let's do it on the 6th then.
6th. 7th, 8th is a holiday here. On this 6th.
6th September.
My lord, I was requested for the week after that, my lord.
What?
11, 12, 13.
It happened on the 12th then, my lord. As a fixed date.
12th. So you are not filing any rejoinder to their affidavit?
My lord, what I would pray, my lord, if at the time of hearing lordship feels that this document can be taken into consideration, because these are civil.
Yeah, once it is filed, it has to be noted. If it is, yes, if it is relevant or not, that's a different thing.
Liberty will be there if they want to file.
Yes. Mr. T.T. Dingro, Leonard, Senior Counsel, appearing for the respondent. All the respondent?
Yes, there's only one respondent.
Only one respondent for the respondent. Has submitted that an affidavit has been filed, bring on record certain factual aspects of this matter. Which was borne out. The Learned Counsel for the petitioners have, however, submitted that rejoinder may not be necessary to be filed at this stage, while at the time of hearing the same may be the issue may be agitated on prayer made by the on joint prayer made by the parties. This is matter for hearing on Kanikadi for hearing.
Hearing.
This is matter on 12th. Fine, 12th.
CRP number 28, I am appearing for the petitioner.
We will take it at the end of the vote and continue to the second half if required.
Yes.
In CRP 28, I am appearing for the petitioner.
The two matters connected.
Same order.
Same order.
Common order.
Item number 13. May I please, Your Lordship, here as per the last order, the state respondents were to seek instruction, Your Lordship. Actually, here what happened, Your Lordship, the petitioner was appointed as assistant teacher at the Pindang Langsting Presbyterian Lower Primary School, Your Lordship, in the way back in the year 1992. Then what happened was, in the year 1993, their school was taken over by the state respondent, White Meghalaya, taking over of the District Council Lower Primary School, 1993. After that, what happened, Your Lordship, the similarly situated teachers were placed as a government teacher, Your Lordship, and they were given pension according to the old scheme, General Provident Fund, Your Lordship. Now, to the exception of the petitioner, Your Lordship, the petitioner had filed a representation also, Your Lordship, after which the state respondent issued a notification treating him also as the state respondent, Your Lordship. But now the state respondents are saying that since he was appointed he was regularized after 2010, so he will come under the new pension scheme. But we are saying that since he was appointed in the year 1992, he will come under the old pension scheme, Your Lordship. Now, simultaneously, what happened in the on 28th April 2023, Your Lordship, the state respondent issued a letter directing the respondent number 8 to resubmit the application of the petitioner in the prescribed GPF form so that his pension could be calculated as per GPF, Your Lordship. So on that point, the state respondents were to seek instruction, Your Lordship.
I have already taken instructions, my lord. My lord, here my lord, this is the second round of litigation, my lord. In the first round of litigation, my lord, petitioner filed a case stating that he is a government employee. My lord, however, going through the writ petition, it was amply clear, my lord, that he was an appointee. He was appointed by the managing committee. It is amply clear, my lord. Therefore, this honorable court also came to a finding that he is not. In fact, this honorable court by the earlier order said, okay, the petitioner may file a representation before the government. It's for the government to take a call, my lord. Now, thereafter, the government took a decision stating that okay, the petitioner's service may be regularized, but with effect from the date of which his service is regularized, my lord. So, having that situation, my lord, the case of the government is that because his service is regularized with effect from such and such date, therefore naturally he will not fall under the old pension scheme. But it is a clear case, my lord. The petitioner was, if I take my lord through the record, it is a clear case the petitioner is not appointed by the government, and neither is the school taken over, as my friend is stating, my lord, and neither is the school taken over by the government, my lord. In fact, earlier round there were four writ petitions which were filed, my lord, on the same contention, my lord. If I remember, 3 writ petitions disposed, my lord, finally, and my lord, no reliefs were granted to the other 3 petitioners. This is the second round of litigation, my lord. However, on the last occasion, I followed up, my lord, how that letter was issued. Now, my lord, that letter was issued because there was a communication which had come from the office of the SDSA. Now, the directorate office which is sitting here, my lord, they are not aware of the situation. So, it is on that account, that letter was issued. But it is nothing otherwise, my lord. However, as far as the current status is concerned, whether he is under the old pension scheme or the new pension scheme, my lord, I have consulted the department, my lord, because it's a finance department is also a part, my lord. So for that, I'll pray for at least a week.
No, but you see now, firstly, if you dispute his status,
yes,
if you say that he is not a government servant,
he's not a government servant.
so where's the issue of
no, my lord, that is exactly why I said
the pension scheme, either new or old or whatever?
No, my lord, here his service was, because as per the direction of this honorable court in the earlier round of litigation, he had made a representation to the government that kindly consider my service as a regularized service.
That was allowed.
Submitted a representation, so the representation was very disposed with a clear direction that his service will be regularized only from the date on which the same is approved by the government, not retrospectively. My lord will kindly see the order of the.
I don't understand. How will you regularize a service of a person,
my lord,
who is not on your roll?
My lord, that was the decision which was taken by the government, my lord. But if I take, my lord, to the order of the honorable court, the writ petition, judgment on order 34 to 36. My lord, if I take, my lord, to the order, this is annexure 4, my lord, starting from 34.
Yes.
The brief facts of the case is that the petitioner is HSLC passed and was appointed as a LP school teacher on a regular basis in a sanctioned post with effect from 1792 on the approval being obtained from the Deputy Inspector of Schools at such and such school, Mairang, West Castles. So my lord will kindly see. It is why the approval comes, because it is the
sanction post
appointed by the managing committee.
No, but against a sanction post.
Yes, every deficit school has sanction posts, madam. So in a deficit school, when an appointment is made by the managing committee, approval will have to be given by the state, madam. So this is exactly what the order says. On approval being obtained from the Deputy Inspector of Schools at such and such place. The pleaded case of the petitioner is that after the enactment of the Meghalaya taking over of the DCLP Schools Act 1993, the petitioner became eligible to be treated as government LP school teacher and as such should be covered by the said act, notwithstanding the fact that the cut-off date was 29/2/1984. As such, the petitioner is before this court with a prayer that the direction be issued to treat the petitioner as a government LP school teacher and his name be included in the order issued wide memo number so and so, my lord. Then I take to para 4, my lord. Mr. S.M. Suna, learned counsel appearing on behalf of this behalf of the petitioner submits that the petitioner have been appointed since the year, not here, this is incomplete, my lord, if I can. The petitioner submits that the petitioner have been appointed since the year 1992 as stated in the petition. Is eligible for consideration and entitled to be given the status of government LP school teacher. The learned counsel also places reliance on the judgment rendered by this court in so and so, my lord, to support his case. He further submits that in this regard, 2 representations have been filed on 19/6/2015 and 28/10/2016. However, the same has not been answered by the respondents. As such, he prays that in the alternative, the respondents may be directed to actively consider the representations so submitted by the petitioner for consideration of his case. Mr. K.B. Bhattacharjee, learned GA, appearing on behalf of the respondent number 1 to 5, firstly submits that the fact that petitioner was initially appointed by the state respondents is disputed and maintains that the appointment has been done by the managing committee, which was subsequently approved by the state. He further submits that there is no order, notification or direction issued by the government of Meghalaya whereby a teacher of a non-government LP school or minority private school is to be recognized and treated by a government LP school. As such, he submits that there being no case made out for issuance of any mandamus by this court, this writ petition is devoid of merit and should be dismissed. I have considered the submissions of the learned counsels for the parties and also examined the materials on record. The only point that deserves consideration is whether petitioner is duly appointed government teacher serving at such and such school, or whether the petitioner has been appointed by the managing committee itself with approval from the respondent authorities. From the service book, this is very important, madam. It is reflected that the appointment of the petitioner is by the managing committee and approval accorded by the Deputy Inspector of Schools. However, in the interest of justice, I propose to dispose the instant writ petition with a direction that the respondents examine the representations filed by the petitioner and to consider the same. At this juncture, the learned counsel for the petitioner prays that he may be permitted to file a fresh representation, which is accordingly allowed. As such, so this is the case. This is the case, and thereafter, my lord.
So what is the fate of the representation?
Representation, petitioner's service was considered, but with effect from the date on which his regularization has taken effect, not from a retrospective date. Now that order is so that is why, my lord, I was praying that as far as the status is
what
concerned.
Is the, have you
as far
have
as
you narrated in your petition what happened after you filed the representation?
Yes, Your Lordship, yes.
Where is the
my lord, as far as this status is concerned, whether
let us go first. As far as this representation is concerned, you said that on the basis of the representation, he
filed after the
his service was regularized.
Regularized with the effect?
With effect from whatever. So where is that order?
It's at para 14, Your Lordship.
What is happened to the
Oh, the annexure.
My lord, the annexure will be at page 42, my lord, annexure 7, and page 43, annexure 8. Before that, my lord, notification is at annexure 6, page 41.
So he has been so he has been declared as a government teacher.
With immediate effect, my lord.
With immediate effect, yes.
Not retrospective.
Not retrospective.
Yes.
Oh, so this will be only in 2019?
Yes.
Yes, Your Lordship. But Your Lordship may kindly come to page 61, Your Lordship. This is a letter from the subdivisional school education officer, Your Lordship.
Yes, obviously, because they are not aware of the situation. Just merely because the shooting down a letter does not mean that his service is considered with the retrospective, on the retrospective date.
See, he government school.
Yes.
No, this is only with regard to this teacher, my lord. This particular teacher.
No, but that should not be the nomenclature used.
My lord.
Because once you say government teacher means, you understand. See, it could be a teacher in, let's say, Pine Mound or
Correct.
public school. Those are government. But as far as we can understand, in my limited knowledge of the cases that I've dealt with, government aided means government aided.
Yes.
They are only accorded some benefits.
Yes, sir.
But not pensionary benefits.
That is the thing.
And GPF for that matter. So if there is some mistake that has occurred, then you cannot take advantage of that. It's for the government to, you should have come with a clarification, or you should have come with a
In the affidavit we have stated, my lord, but however, as far as because from the finance department, they said that it should be taken from this is also as per rules, my lord, from the date on which his regularization is, service is regularized, my lord.
How do you regularize the service? I don't understand.
That is the point, my lord, but rightly or wrongly, this has been done, my lord. So on that, my lord, what is the ultimate status, because petitioner was asked to submit a form for this NPS, but the petitioner refused because he wants that it should be considered under the GPF.
No, he was again, Your Lordship, he was again asked to resubmit the papers in the GPF format, Your Lordship.
That is.
Then why this communication is there, Your Lordship, if he is not a government servant?
So 2 weeks time may be given, my lord. I'll get the current situation.
You have made, in fact, the government has made a blunder.
That is.
But two wrongs doesn't make a right. It's like if people charging an G has something that he may be given some more time to seek necessary instructions in this regard. What are the instructions required?
My lord, what is the current status? Whether the petitioner has been asked to submit his GPF or under the new pension scheme, my lord, whether NPS.
Papers are here.
No, my lord, this is not the latest because I have inquired because the director office was also, there was some confusion there.
As regard the case of the petitioner, pertaining to as to whether he was directed to, as to whether he is eligible for GPF subscription or NPS, as the case may be.
Lordship, I'm appearing on behalf of respondent 6.
Who are you?
AG.
The Accountant General.
What has the AG got to do?
Basically, no role.
Right, at this point, the juncture, they don't have any role, my lord.
We'll see as and when required. Just I don't miss you appears for AG. How long?
Well, I'll pray for 2 weeks.
As prayed for, this is matter up to 2 weeks. But get it, you have to clarify. Otherwise,
Much obliged, Your Lordship.
Item number 15.
Please, Your Lordship. Your Lordship, in this matter, I'll be praying for a further 3 weeks' time. Your Lordship, the conducting counsel, Mr. K.C. Gautam, is on legs before courtroom number 2. Also, Your Lordship, in this matter, we will have to delve into the technicalities of Section 256 of CRPC, wherein in this matter, as per order dated 15/06/2023, the learned court of the Judicial Magistrate First Class had acquitted the accused on the count of non-appearance of the complainant. Now, Your Lordship, it is pertinent here to mention that the case had been fixed. The case at that time had been fixed for steps. Section 256 has made it very clear that the case can only be under Section 256. The case can be dismissed at the hearing stage. So, Your Lordship, we require more time, Your Lordship, to delve into that matter a little bit so that we can aid Your Lordship in coming to a proper conclusion.
You're for the
petitioner.
Who's appearing for the respondent?
Notices have been served, Your Lordship. We have filed our affidavit for confirmation of service also, but no one has entered appearance.
Two weeks.
3 weeks, Your Lordship.
On pre-made by the petitioner. This is matter for 3 weeks.
All right, Judge.
Item number 16.
In this matter, the only issue that falls for Your Lordship's consideration is whether, my Lord, in respect of an offence under Section 188 and 109 IPC, my Lord, whether it is permissible for the police to file a charge sheet based on a FIR, based on an FIR, my Lord. Lord, here the law is settled in that regard. I'll just take Your Lordship to Section 195 of CRPC, my Lord. Lordship is aware that there is a bar under Section 195 insofar it relates to Section 172, 188 of the IPC, both inclusive, my Lord, for any court to take cognizance of any offence in respect of those offences which are enumerated under Section 195, my Lord. No court shall take cognizance, Section 195, my Lord, of any offence punishable under Section 172 to 188, both inclusive of the Indian Penal Code, or of any abatement or attempt to commit such offence. Now, in my case, my Lord, we fall under Section 188 and 109, which will be under the Category 2, my Lord, Category 2 of Section 195. Subsection 1(2), my Lord. 109 will fall under the abatement. Now, I'll take Your Lordship to the proviso. No court shall take cognizance except on a complaint in writing of that court, or by such officer of the court as that court may authorize in writing in this behalf, or of some other court to which that court is subordinate.
Where you are reading it?
My Lord, I am reading the proviso to Section 195. Not a proviso, but my Lord, the part of the later part of Section 195. No court shall take cognizance of any offence punishable under Section 172 to 188 of the IPC, of any abatement of attempt to commit such offence, or the rest are not relevant, my Lord, except on the complaint in writing of that court, or by such officer of the court as that court may authorize in writing in this behalf, or of some other court to which that court is subordinate.
So I think this provision would relate to a situation where there's a
violation of any
violation of court order.
Yes.
An affront to the authority of the court.
Yes. In this case, even though, my Lord, there was an order by this honorable court in the earlier round of litigation, in fact, there was no violation per se on the part of accused person or anybody involved in that case.
due to some misunderstanding, some skirmish happened, my lord, and the issue actually had already been settled. But because of some skirmish, my lord, which happened after the passing of the order, my lord, the FIR came to be lodged by the police officer. Now, on the basis of an FIR, charge sheet was filed under these two sections. Now, my lord, so far as the provision of 195 is there, it's very clear. I have some authorities, my lord, in this regard, passed by the Honorable Apex Court. It's a three-bench order, a three-bench judgment of the Honorable Apex Court. Yeah, 1962, SC 1206. I'll take your lordship to paragraph 3. The only question, my lord, if our lordship has got it.
Yes.
The only question in this case is whether a complaint in writing, as required by section 194, has been presented by the public servant concerned. The public servant who is moved by the appellant, who was moved by the, these are not relevant, my lord. I'll take your lordship to the ultimate page of this paragraph. The word of section 195 of the Criminal Procedure Code are explicit. The section reads as, no court shall, the last, the end of this particular paragraph, my lord. No court shall take cognizance.
No court shall take cognizance
of any offence punishable under section 172 to 188 of the IPC, yes, except on a complaint in writing. It is marked in italics, my lord.
Yes.
Except in writing to the public servant concerned or of some other public servant to whom he is subordinate. The word of the section, namely that the complainant has to be in writing by the public servant concerned, and that no court shall take cognizance except on such a complaint, clearly shows that in every instance the court must be moved by the appropriate public servant. We have to decide whether, therefore, whether the Tehsildar can be said to be the public servant concerned, and if he had not filed the complaint in writing, whether the police officer in filing the charge sheet had satisfied the requirement of section 195. The word no court shall take cognizance have been interpreted on more than one occasion, and they show that there is an absolute bar against the court taking cessation of the case except in the manner provided by the section. Now, paragraph 4, my lord. Now, the offence under section 182 of the IPC, if any, was undoubtedly complete when the appellant had moved the Tehsildar for action. Section 182 does not require that action must be taken if the person who moves the public servant knows or believes that action would be taken. In making his report to the Tehsildar, therefore, if the appellant believed that some action would be taken and he had no reasons to doubt that it would not, the offence under the section was complete. It was therefore incumbent, if the prosecution was to be launched, that the complaint in writing should be made by the Tehsildar as a public servant concerned in this case. On the other hand, what we find is that a complaint by the Tehsildar was not filed at all, but a charge sheet was put in by the station house officer. The learned counsel for the state government tries to support the action by submitting that section 195 had been complied with, inasmuch as when the allegation had been disproved, the letter of the SP was forwarded to the Tehsildar and he asked for a calendar. This paper was filed along with the charge sheet, and it is stated that this satisfies the requirement of section 195. Now, this is the observation made. In our opinion, this is not a due compliance with the provision of section 195 of that section. What the section contemplates is that the complaint must be in writing by the public servant concerned, and there is no such compliance in the present case. The cognizance of the case was therefore wrongly assumed by the court without the complaint in writing of the public servant, namely the Tehsildar in this case. The trial was thus without jurisdiction ab initio, and the conviction cannot be maintained. All right, I have another judgment.
Yes, Mr. Thapa, if you are going to the the proper hearing, then I think better first go to the facts of the case.
No problem, my lord.
Who's there for the
What happened in this case is,
Registered as well as the private. She is the informant in this case. So I am representing both.
what happened in this case is, my lord, there was a dispute between two factions of
Please continue.
There was some dispute with regard to my lord, the priest who was to perform, my lord, the pujas at the Natyang temple, my lord.
Yes.
That was sometime in the year 2018, my lord. And as a result of which, my lord, both the parties approached the Honorable Court seeking, my lord, some kind of a remedy from the court to
restrain,
declare as to who would be the best person to, my lord, perform pujas. My lord, in that regard, my lord, some orders were passed, and finally, my lord, this the court left it to the discretion of the people, and the good sense prevailed over them. And my lord, they reached a conclusion that, and they rather decided to put a quietus to the entire issue, and they decided to settle the matter, my lord. That your lordship will find at page 1810 page 13, annexure 1. The order is dated 1810/2019.
Page 13.
Page 13, my lord.
Yes.
Yeah, I'll just read your lordship. The grievance in this writ petition filed under Article 225 of the Constitution of India is against the illegal arbitrary action of the respondent number 5 and 6 in not accepting the public opinion support for deciding the priest of Natyang Durga temple in terms of the order dated so and so passed by this court in writ petition 298 of 2018. It has been claimed that there was no resolution in the public meeting held on so and so to decide the next priest, as the respondent had been repeatedly creating a situation of turmoil in the Natyang village, as they could not choose a priest of their choice. Learned counsel for the parties agreed that during the pendency of the writ petition, the dispute has been amicably settled between the parties, and Shri so-and-so, whose family had been performing the rituals as priest for 26 generations, has been allowed to continue as the priest of Natyang Durga temple. It was thus prayed that in view of the above, the writ petition has been rendered infructuous and may be disposed of as such. My lord, after this settlement of the decision with regard to the settlement of who is to now perform puja, my lord, this writ petition was disposed of. Now, what happened after that, my lord? When this person took over as the priest of that particular temple, my lord, again some kind of a misunderstanding arose between the members of the locality, and some skirmish happened. Now, since there was some skirmish happened, my lord, the police had lodged an FIR, and my lord, may kindly note, it was not by any officer authorized by the Honorable High Court, or anybody or by any person who's authorized to file a complaint under section 195. It was purely on the basis of an FIR, that too lodged by the police officer, my lord. After this FIR was filed, my lord, the investigation was carried out and a charge sheet was filed. My lord, the charge sheet was filed under section 147, the FIR was filed under 147, 148, 149, 188, 353, 323, and the charge sheet came to be filed only under section 109 and 188. Now, my lord, after this, when the matter came up before the trial court, my lord, this was brought to the trial court's notice that under section 188 and 109, there's a specific bar under section 195. And my lord, of course, 188 is something, 188 is compoundable. And therefore, my lord, since the parties have already settled the matter, no useful purpose would be served if this trial proceeds. My lord, the learned trial court passed an order, which your lordship will find at page, it was a very elaborate order, very lengthy order, 5/1/2023 at page 28. I'll just take your lordship to the operative portion. Page 28, my lord.
The order is 5/1/2023.
Yes. Please.
I'll take your lordship straight to page 47, my lord. There's the observation made. Page 47. On hearing both learned counsels, perused record and found that the section alleged against the accused person so and so is under section so and so, and on perusal of the section found that the same are not non-compoundable. Hence, this court is of the view that the fact that the matter has been settled and resolved by the parties is not maintainable. Furthermore, on perusal of the statement of the so and so and witnesses found that there is a prima facie case against so and so for offence under section so and so. Hence, this court is not inclined to discharge the accused person at this stage. Now, in my humble and respectful submission, my lord, the court had no jurisdiction whatsoever to pass this order. And this order, in view of the Supreme Court judgment, my lord, is a void ab initio, my lord. And why I say this is because, my lord, first of all, the charge sheet itself could not have been filed in view of the laws laid down by the apex court. My lord,
but an FIR has been filed by a public servant.
He is a public servant, my lord, but the my lord, the writings in section 195 doesn't talk about public servant, my lord. It has to be by the public servant concerned whose order has been violated.
Okay.
So, my lord, here, first of all, the police have the prosecution as well as the trial court has erred in three different aspects, my lord. First of all, the court could not have taken cognizance itself. Here in this case, my lord, first of all, the FIR could not have been filed. The charge sheet could not have been, the court could not rely on a charge sheet based on an FIR because the reading of section 195 is very clear. It has to be by way of a complaint. Now, secondly, my lord, the trial court could not have even taken cognizance, leave alone passing of any order. The trial court could not have taken even the cognizance of this case. Now, by doing so, my lord, the trial court has completely erred in law. And the orders which followed thereafter is all illegal and and void ab initio. Like I said, my lord, I have already cited the authorities, my lord. I have another authority in this regard, and this position, my lord, it's no longer a sitting gra. It's been settled and reiterated time and again. And so far as section 172 to 188, my lord, in view of the bar under 195, the court could not have taken cognizance, especially if it is not by way of a complaint and rather by way of an FIR and a charge sheet. Well, I'll take your lordship to this judgment. It's 2010 volume 9 SCC 567, which I have just provided, my lord. It's in the case of C. Muniappan and others versus State of Tamil Nadu. Para 33, my lord, page 584. And again, my lord, in this particular judgment, the one which I just cited earlier, my lord, that has been relied upon. I'll take your lordship from page 32 itself. Sorry, para 32 at page 583. If I may read, my lord. Yes. In Daulatram versus State of Punjab, this court considered the nature of the provision of section 195 CRPC. In the said case, cognizance had been taken on the police report by the magistrate, which is in our case also, my lord, and the appellant herein had been tried and convicted, though the public servant concerned, the Tehsildar, had not filed any complaint. This court held as under. The cognizance of the case was therefore wrongly assumed by the court without the complaint in writing of the public servant, namely the Tehsildar in this case. The trial was thus without jurisdiction, ab initio, and the conviction cannot be maintained. The appeal is therefore allowed and the conviction of the appellant and the sentence passed on him are set aside. This is the very judgment which I earlier cited, my lord. Para 33, my lord. Thus, in view of the above, the law can be summarized to the effect that there must be a complaint by the public servant whose lawful order has not been complied with. That was a query which had fallen from your lordship, that the police is a public servant. This will clarify that, my lord. It has to be a public servant whose lawful order has not been complied with.
The complaint must be in writing. The provisions of section 195 are mandatory. Non-compliance with it would vitiate the prosecution and all other consequential order. The court cannot assume the cognizance of the case without such complaint. In the absence of such a complaint, the trial and conviction will be void ab initio, being without jurisdiction. My case is very limited to this extent, my lord, that the police as well as the court could not have, first of all, the police could not have lodged an FIR in this case, could not have filed the charge sheet, and the learned trial court could not have taken cognizance of the charge sheet based, which is based on an FIR and not a complaint. And my lord, leave alone not to talk of the orders passed therein, my lord. I humbly pray, my lord, the proceeding that is pending before the trial court will be quashed and set aside for non-compliance of section 195, and my lord, in view of the law laid down by the apex court, because any proceeding further with the trial would just be a futile exercise and an absolutely wastage of court's precious time, my lord.
Yes, Mr.
Here my friend has raised two issues. Here, admittedly, there are dispute between two rival groups, lordship.
Yes.
On that day, the police went to implement the order of this court, and they were obstructed. The police were obstructed by the mob led by the petitioner hearing. As a consequence of which, the proceeding was initiated, lordship. And my friend, what he is saying, that 195 specifically says that the public servant whose order has been violated, he is the only authority to lodge the complaint on the FIR. Now here, lordship, the order has been passed by the High Court, and who is the authority to implement the order passed by the judiciary or any administrative authority? It is the police, lordship. So the police, he is a government servant, public servant, and he has every right, every lawful authority to lodge the FIR as well as the complaint for obstructing or violation of any court order passed by the honorable court, lordship. And so far as another issue, lordship, my friend has raised that matter has already been settled. Now the matter has already been settled between the rival groups, not with the police. There is no settlement occurred between the petitioner and the complainant, who is the police officers. So that grounds also will not support the petitioner's case, lordship. And lordship, here, lordship, many witnesses are list to be given, lordship. So this is a fit case to be tried by the court below, lordship, and my friend can raise all those issues before the trial court, lordship.
The only thing, Lord, of course, my learned friend has not rebutted or made any submission with regard to the legal position that it stands as on today, so far as section 195 is concerned. And what my learned friend is saying, that the police officer is also authorized by the court. In that regard, I would refer to section 340 of the CRPC. If the court is a high court whose order is alleged to have been violated, then what is the procedure is to be followed is provided in section 340, my lord. Section 340, my lord.
Yes.
Subsection 2, I think it is subsection 3, my lord. Subsection 3. A complaint under this section, my lord, first of all, I'll read it from the beginning. Procedure in cases mentioned in section 195.
Yes.
When upon an application made to it in this behalf or otherwise, any court, it is only when an application is made. Any court is of the opinion that is expedient in the interest of justice that an inquiry should be made into any offence referred to in clause B of subsection 1 of section 95. So, my lord, ideally, when an orders of any court is alleged to have been violated, my lord, the person aggrieved, it is the requirement under the law as per section 340, my lord, that he should make an application to the court concerned. He cannot go directly by way of an FIR. He has to make an application to the court concerned. Be made into any offence referred to in clause B of subsection 1 of section 95, which appears to have been committed or in relation to a proceeding in that court, or as the case may be in respect of a document produced or given in evidence in the proceeding in that court. Such court may, after such preliminary inquiry, if any, as it thinks necessary, record a finding to that effect, make a complaint. This is not relevant, my lord. The powers conferred on a court by subsection 1, I am reading subsection 2, my lord,
Yes.
in respect of an offence may, in any case where that court has neither made a complaint under subsection 1 in that respect of that offence, nor rejected an application for making of such complaint, be exercised by the court to which such former court is subordinate within the meaning of subsection 4 of section 195. Now, subsection 3 is very relevant. A complaint made under this section shall be signed where the court making the complaint is a high court by such officer of the court as the court may appoint. Now, in this case, if at all the allegation is that the Honorable High Court's order has been violated, then, my lord, the complaint has to go from the High Court, and, my lord, it must be filed by an officer who has been appointed by the court. And in this case, the police officer has never been appointed. It's not a case of any court's order violation, my lord. If had it been a violation of the court's order, contempt proceeding would have lied. But here, the order which they alleged that the obstruction of the order which they alleged has been violated, my lord. There is no direction in that order. It's an order. It's an order simpliciter, my lord, that the parties have settled the matter. The matter rests at that, and the writ petition is disposed of. There's nothing to say or even to state, my lord, that anything done against that order would amount to violation of that order, my lord. So, therefore, my lord, the police officer is not an officer competent to file a complaint. Even if he is competent, my lord, he has not filed a complaint. It has to come by way of a complaint. FIR is absolutely not within the purview of section 195, my lord. In this case, there was an FIR, charge sheet filed, court took cognizance. Everything was done in a very perverse and illegal way, my lord, in complete violations of my lord, breach of section 195. Therefore, my lord, the proceeding before the trial court do not sustain, my lord, and therefore I humbly pray, my lord, it may be set aside and quashed in view of this, my lord, the judgment laid down by the Honorable Apex Court.
Yes, anything else? What the parties are passing orders?
Obliged.
Second call from supplementary cause list, item number 5.
This is again another bail application similar to, identical to item number 3 and 4, Lordship. Here also, Lordship, an FIR was lodged on 17/12/2022, Lordship.
So same order.
Same order, Lordship, because it's arising from the same
PS case, Lordship. FIR was lodged. Only difference is, Lordship, I was given notice under section 41A. I had duly complied. Despite that, Lordship, I was arrested.
Yeah, you were arrested.
Yes, Lordship, I was arrested.
Reasons were given?
No, Lordship. We have not been supplied with anything, Lordship. In fact, Lordship, on 26th, I was called there again, Lordship, to give my statement. I duly complied, Lordship. I went there, I given my statement, Lordship, and from there, my Lord, I was arrested, Lordship.
Same case.
Same case. From the same PS case.
CD may be
CD, if called, will cover your case.
Yes, it's the same case.
Same order.
Same order.
Same order. Obliged.